So the American government has three branches in total, including the legislative, the executive, and the judicial. Although all three branches are very important, the main concern here is judicial, as their role is to interpret the laws and apply them to specific cases. In the US, the judicial representative is the Supreme Court, which plays a pivotal role in upholding the rule of law. And there are a total of 9 justices, 1 Chief Justice, and 8 Associate Justice. The Supreme Court is divided into 2 main branches, the US Court of Appeals and the State Supreme Courts. While each state has its own laws, there are also common laws that apply to all states, simplifying matters like taxes on imports and export. Judicial review stands as one of the most powerful tools of the court, enabling the judicial branch to exert control compared to the other 2 branches of government. It ensures that legislative acts and executive actions align with the law and adhere to constitutional principles.
We should notice that all 3 levels of the judiciary have 3 basic requirements. The first one is jurisdiction, which refers to a court's authority to hear and decide a specific legal action. There are some dimensions of jurisdiction that we will explore, including in personam, in rem, subject matter, original, and appellate jurisdiction. The first dimension is in personam. In personam jurisdiction deals with cases where the court has authority over the parties involved based on their physical presence or activities. Let's consider an example. Mary lives in Texas but is currently on vacation in Florida. During her trip, she purchased a diamond, but she then realized that it was a fake one. In this case, she would have to sue the jeweler in Florida, as the transaction took place within that jurisdiction. The second dimension is in rem jurisdiction, which refers legal term describing the power a court may exercise over property. For instance, during a divorce, the property the parties owned must be under jurisdiction of the court before the court can determine who gets what. Moving on to the third dimension is subject matter jurisdiction, which refers to a court's authority to hear cases related to the specific subject matter. For instance, a bankruptcy court has the authority to hear only bankruptcy cases. The following dimension is original jurisdiction, which refers to court's authority to hear a case for the first time. For instance, municipal court has original jurisdiction over traffic cases within the city. The final dimension is appellate jurisdiction, which refers to court's authority to review decisions made by lower courts. Moving on to the second requirement, venue determines the geographical location where a trial is held and from which a jury is selected. The final requirement is standing to sue. This means that a party must have a sufficient stake in the dispute to justify seeking relief through the court system.
A notable case that illustrates the importance of judicial reviews is Department of Homeland Security v. Regents of Universities of California, 2020. This case revolved around the legality of Trump administration's decisions to resign the Deferred Actions for Childhood Arrival (DACA) program, which offer protections and work permit to certain undocumented immigrants who arrive in the U.S. as children. In 2020, the Supreme Court upheld the lower court decisions that the resistance of DACA by Trump administrations was arbitrary and capricious. Under Administrative Procedure Act (APA), the court have ruled the administrations failed to provide sufficient justifications for ending the program and violated procedural requirements. This case demonstrated the vital role of judicial review in ensuring executive actions comply with the law and adhere to constitutional principles. It affirmed the principle that administrative agencies must operate within legal boundaries and follow proper procedures when making significant policy changes. The court's decisions have significant implications for the rights and protections of hundreds of thousands of DACA recipients and emphasize the importance of judicial oversight in maintaining check and balance within the government.
In our daily life, conflicts happen all the time, and in business, conflicts happen too. You may think that every time a dispute appears, people settle them in court. However, we have to say that this is a misconception. In fact, more than 90% of conflicts are resolved by the Alternative Dispute Resolution, or can be called ADR. Litigation is the process of resolving a dispute through the court system, and in contrast to litigation is ADR. Alternative dispute resolution simply explained as a method for avoiding formal litigation in court. Then, why do people prefer ADR? Normally, civil cases are usually resolved before reaching a judge or jury, and we call this process ADR. ADR offers an alternative via arbitration and conciliation for that process and is often faster and less expensive, preservation of relationships and financial provisions for all. Moreover, ADR is less risky than trial. There is no guarantee at the court for a fair and favorable decision. In the ADR process, parties negotiate to come up with the most satisfactory outcome, while at the trial, a judge or jury decides the case, which might lead to unintended outcome. And finally, ADR proceedings are private. Court records and proceedings, on the other hand, are open to the public, and the adversarial nature of litigation tends to bring to light long-held secrets or embarrassing facts and claims.
So, what are the forms of alternative dispute resolution? There are three basic forms of alternative dispute resolution, including negotiation, mediation, and arbitration. Negotiation is exactly what it sounds like. Parties in this process simply sit down and have conversations to reach the most satisfactory result. In case the negotiation fails, we need a third party to help solve the problem. Both mediation and arbitration have the appearance of a third party. However, in mediation process, the third party will be a neutral party and will try to give out different perspectives to help the disputing parties can reconcile. The neutral party can only give suggestions without any authority to decide the final outcome. In contrast, arbitration is the process by which the disputing parties present their argument and prove them to the arbitrator. Just like in sports, there's an arbitrator who gives decisions during the game. Arbitrator in law also be the one to give the final results to the parties. Usually, the settlement of disputes will be set out in the contract. However, in most cases, people will often prioritize negotiation, then conciliation if negotiation fails, and finally, arbitration when conciliation cannot solve the dispute.
In today's technology age, there is a term called online dispute resolution, ODR, which is simply a form of dispute resolutions that use the technology to facilitate the resolution of dispute between parties. For example, this European RODR platform provided by the European Commission makes online shopping safer and fairer. Consumers in the EU used it to find the best solution for their consumer problems, to discuss a solution directly with a trader concerning their problem, or to agree on a dispute resolution body to handle their case. All you have to do is put your information in this system, put your address and where you bought that product, and what problems do you have with the trader, and they will show you some resolution that they suggest you can agree or not. If you want to take it serious, you can have a discussion with the trader directly. So it is very simple to handle the case at home.
Every day, there are lots of disputes over various issues such as commercial, property, and other things. And these disputes may even happen among nations. So when there's conflict, who will be the one to help you with it? The answer is, in the world, there are several organizations that provide you the third-party assistance, and these assistants will help you to solve the international disputes. The aim of these organizations is to facilitate the peaceful resolution of conflict and also promote the stability and cooperation among nations. Prominent examples include International Mediation Institute, International Institute for Conflict Prevention and Resolution, Singapore International Mediation Center, International Dispute Resolution Center, and finally, United Nations. And this is also the end of what we need to know about courts and alternative dispute resolution. Thanks for watching and have a nice day.